The thing about the Chambers intercom in the east wing of the federal courthouse, every clerk in the building knew it, every judge knew it, the chief of facilities certainly knew it, was that the toggle that switched a private chamber conversation to the public courtroom speakers was not, by any reasonable standard, well designed. It was an old brass switch on a 1978 panel. It had two positions, marked C for chambers and X for external. It had been left in the X position more than once over the decades, and the building had a folklore of moments small and large that had spilled, by accident, from one room to the other. None of those moments, the junior magistrate in the back row of courtroom 12 would later say, had ever quite been like the moment that happened that Thursday afternoon at 2:10. Magistrate Anya Brennan had been a federal magistrate judge for 14 months. She was 38, had clerked her way up through 2 circuits, had 3 young law clerks of her own whom she trusted, and had, like every other magistrate on the floor, been told, on her first day, the specific things one watched in a federal courthouse. She had been told by the senior judges over coffee that you watched the way the building treated the people who had not slept in 2 nights. She had been told you watched the way lawyers treated the bench when the bench had stepped out. She had been told, in particular, you watched what happened to a federal judge after the building decided a settlement was inconvenient. The case in courtroom 12 that Thursday was Hernandez and others v. Merrow Chemical Partners. It was a 6-year-old toxic exposure case on behalf of 140 former employees of a now-closed plant in the Ohio Valley, whose long, careful, painstakingly documented claims had finally, after 2 changes of venue and 1 attempt at federal preemption, arrived at a settlement hearing in front of Judge Lillian Reyes. Judge Reyes was 61, had been on the federal bench for 9 years, had 2 daughters in school, drank her coffee black, and had, in 9 years on the bench, never raised her voice in court. She also had, that Thursday, the entire defense team of Merrow Chemical's lead outside counsel sitting in front of her, a senior partner named Vincent Hollander from a global firm whose marketing materials used the word elite without irony. Hollander had asked for an in-chambers conference. He had asked for it the way lawyers like Hollander asked for things, implicitly, casually, as though the chambers conference were a courtesy he was offering the bench rather than a thing he was requesting. Judge Reyes had granted it. She had told her courtroom that the bench would take a 15-minute recess and called Hollander, his second chair, and the plaintiff's lead counsel, a soft-voiced attorney named Esperanza Vega who had carried the case from the beginning, into chambers at exactly 5 minutes before 2. What no one in the chambers knew, what Hollander, in particular, had no way to know, because he had not been a regular in this building for 9 years, was that the chambers intercom panel had, at the end of the morning, been bumped while the maintenance staff replaced a fluorescent tube above the bookshelves. The brass toggle had drifted from C toward X not all the way, just enough. The courtroom, when the chamber's door closed behind them, did not empty. 6 families of plaintiffs sat in the front rows. Magistrate Brennan, who was scheduled to take a settlement docket of her own in the same room at 3, had come in early to watch the end of the recess. 3 reporters from the local press who had been following the case for years had stayed in their seats. The court reporter, a careful woman named Joyce, had stayed at her stenograph. The bailiff, a senior deputy named Marquez, had stayed by the front door. For the first 8 minutes, the chamber's intercom carried only the muffled sound of paper shuffling. The C2X drift was not, at that point, audible. Then Hollander began. What the room heard at first was a voice that did not yet sound like a voice in chambers. It sounded like a voice in a conference room in Midtown Manhattan. It said very pleasantly, "Lillian, let's be candid. The settlement number my client is offering today is the highest number my client will offer. You are going to approve it. You are going to approve it, and you are going to do so in the next 20 minutes, because if you do not, we are going to be in a different conversation." There was a half-second of silence. Then Judge Reyes's voice, recognizable to every clerk in the building, came through clean. "Mr. Hollander, you will address this court as your honor, and you will not threaten this court in chambers." "This isn't a threat, Lillian," Hollander said. "This is a courtesy. I have been doing this work for 32 years. You have been a judge for 9. You do not understand what my client can do to a federal nomination. You do not understand what my firm can do to a judicial career. You should sign the order I've put in front of you. You should sign it and let this case end. You should not, with all due respect, try to play hero in a courtroom in a small-town district. Magistrate Brennan would say later, months later, when she had been asked to recount the moment for the disciplinary panel, that the first thing she felt was not anger. It was nausea. She had heard in her clerking years what corner office partners said behind closed doors when they thought the bench had stepped out. She had not, until that afternoon, ever heard one of them say it on speakers, in a federal courtroom, in front of the very plaintiffs whose case it was. The bailiff Marquez, by then, had taken half a step forward. The court reporter Joyce had begun, without anyone telling her to type. The reporters in the gallery had stopped breathing for a long moment. Then, slowly, one of them lifted his phone above the rail. Esperanza Vega's voice came through next, quiet but unmistakable. "Mr. Hollander, I think the panel is open." There was a pause, then Hollander more sharply, "What?" "The intercom panel," Vega said. "Above the bookshelves, I think it's on." Another pause. Then a third voice, Hollander's second chair, a younger associate, said, "The way a man says it when his stomach has just dropped, sir." Hollander did not, even then, fully understand. The room could hear him understand it slowly. They heard him say, "Don't be ridiculous." They heard him say, "There's no that doesn't." They heard, very faintly, the chair scrape as someone, probably the second chair, probably for his own self-preservation, crossed the room toward the panel. They heard a small click. They heard Judge Reyes say very evenly, "Counsel, sit down, all of you. The chamber's conference is over. We are going back into open court." Magistrate Brennan saw, from the back, the chamber's door open. Judge Reyes came out first. She did not look at the gallery. She did not look at the press. She walked in her robe in the steady, measured pace of a woman who has worked 9 years to teach a building how to walk steadily, back to the bench. She sat down. She lifted her reading glasses. She nodded once to Joyce at the stenograph. "We are back on the record," Judge Reyes said. "Mr. Hollander, you will rise." Hollander rose. He had by then lost something in his face. His suit had not lost anything. His face had. "Mr. Hollander," Judge Reyes said, "for the last 14 minutes the chamber's intercom panel was, by maintenance error in the external position. Everything you said in chambers was carried live on the courtroom speakers. The court reporter has transcribed it. The bailiff has noted it. Members of the press are present. The plaintiffs are present. The record is complete." Hollander said nothing. There was nothing in his 32 years that he had prepared to say. "In the presence of counsel and the court reporter," Judge Reyes continued, "you threatened a federal judge in chambers, you attempted to coerce the approval of a settlement, and you invoked your firm's influence over judicial appointments as leverage. I have heard a great many things in 9 years. I have never heard those things. They are now on the record." She turned a page. She lifted her pen. "The court finds you in summary contempt of this court. You are remanded to the custody of the United States Marshals for processing. The court will refer this matter, in writing, to the disciplinary committee of the state bar in which you are admitted, to the disciplinary committee of every state in which your firm is admitted, and to the Office of Professional Responsibility of the Department of Justice for review of any pattern. The court will also refer the conduct of your firm to the Federal Judiciary's Standing Committee on Attorney Conduct. Your second chair is excused from those referrals pending the committee's findings." She looked at the second chair, who was now standing because he had not realized he was supposed to sit. "Counsel," she said gently, "you may sit." He sat. She turned to Esperanza Vega. "Ms. Vega, the settlement before the court is plainly inadequate on the public record now available. The defense's posture has been clarified. The court will not approve the proposed settlement today. We will reconvene at 9 on Monday morning. I expect the defendant to be represented by different counsel and to bring a number that reflects the gravity of what the public record now contains. We are adjourned." The bailiff Marquez and a second deputy came forward. They did not hurry. They did not raise their voices. They took Hollander gently by the elbows and walked him without ceremony through the side door. He did not speak. He did not, this time, even sneer. He went the way a man goes who has not yet finished understanding what he has just done. In the gallery, the 6 families of plaintiffs sat very still. They were not, Brennan noticed, celebrating. They were not, any of them, smiling. The widow of a man who had died of a slow lung condition 7 years before, who had been holding the same handkerchief in her hand for the entire hearing, did not lift it to her face. She did not weep. She closed her hand around it. She nodded very slightly to her son next to her. He nodded back. The reporters at the rail were already, Brennan could see, on their phones. By 3 o'clock, the recording would be on every legal blog in the country. By 5, it would be on the national wire. By 7, the firm whose marketing materials used the word elite without irony would have called a midnight meeting and decided by morning that Vincent Hollander was no longer a partner. Monday at 9, the case would not in any meaningful way be the same case. The new defense team would arrive with a new posture and a new number. The number would not, in the end, restore the men the plant had killed. It would restore, as much as the law could restore, the people the men had left behind. It would pay for the medical care the widows had not been getting. It would pay for the surviving children's education. It would pay, by court order, for the long-overdue independent environmental remediation of the plant's old footprint. It would not, anyone in the gallery understood, undo. But it would do, and lawfully, what could be done. Judge Reyes finished signing the contempt order before she stood. She did not look at the press. She did not look at the empty defense table. She looked for one short second at Esperanza Vega, who had been carrying the case for 6 years on a contingency that had cost her firm 2 associates and a copier. She nodded once. Vega nodded back. Magistrate Brennan would write, that night, the first paragraph of what would become a teaching note for the next year's clerk orientation packet. The first paragraph read, "The Chamber's intercom in courtroom 12 was in the external position. The conduct of a senior partner of an elite firm became a federal record. The conduct of the judge, calm, patient, measured, and entirely on the books, became a federal record beside it. The lesson is not the panel. The lesson is the bench. When the law is given a quiet room to work in and a complete record to work from, it does the work." The chief judge of the district, who had heard the audio by 4 o'clock, called the chief of facilities personally that evening. The intercom panel in courtroom 12 was, by the next morning, replaced with a modern unit that had no toggle and that could not, by any maintenance accident, be left in the external position again. The replacement was, the chief judge would say later at a bar association lunch, both prudent housekeeping and slightly beside the point. The misalignment of the brass toggle had, that afternoon, done a public service the building's architects had not designed it for. The building, in fairness, was bigger than its panels. It had, in the building's own quiet way, made the panel a teaching tool. Then it had, with characteristic care, replaced the panel. In the corridor that evening, after the courtrooms had emptied, Magistrate Brennan stopped Esperanza Vega by the elevators. Vega was carrying a brown accordion file that had been Marrow's lead binder for 6 years. She looked tired the way one looks tired after a marathon, not after a setback. "Ms. Vega," Brennan said, "I wanted to say that was." Vega smiled the smallest smile. "Thank you, yes, I know." "I have to ask," Brennan said. "Before the intercom, did you think you were going to be able to get this where it needed to go?" Vega thought for a moment. She looked at the file in her arm. She looked at the line of judicial portraits on the corridor wall, fictional faces in old-fashioned frames, decades of district judges, every one of them a man until 20 years ago. "I thought," she said, "that I was going to get it as far as Judge Reyes. I thought after that the law would have to decide whether it was going to help me carry it. Today it decided. By accident. The accident was real, the decision wasn't." She nodded to Brennan. She got into the elevator, the doors closed. Brennan stood in the corridor for a long minute and listened to the elevator descend. The hallway was quiet. The portraits, the old wood, the carved stone of the entablature over the courtroom doors, all of it had been built, she thought, for exactly this. For the moments when the law decided whether it was going to help carry the weight. For the moments when a 32-year partner of an elite firm tried to bend the room, and the room, instead, recorded him. For the moments when a 61-year-old judge sat very still and let the record fill, and then turned the page, and then signed. The lawful consequences would, over the months to come, land in their proper order. Hollander would be disbarred in 2 of the 3 states in which he was admitted. The firm that had used the word elite would, by autumn, restructure and rebrand. The Merrow plaintiffs would, by the end of the year, receive the first checks of a settlement that did not pretend to be a kindness. That was, by court order, an acknowledgement. The intercom panel would be replaced. The teaching note would be circulated. The young law clerks reading it would learn, in the only way one learns these things, what a federal bench is supposed to be for, and what it is supposed to refuse to be for. Magistrate Brennan made her last note of the day and turned off her office light. On her way out, she passed Judge Reyes's chambers. The door was open. Judge Reyes was at her desk, signing what looked like the last page of the contempt order, her pen moving in the steady, unornamented pace of a woman who had been keeping her promises to the building for 9 years. Brennan did not interrupt. She walked past the open door and down the corridor and out into the cool evening, and she thought, all the way to her car, about the quiet sound of a brass toggle that had drifted, by accident, into the position the building had needed it to be in. The building, in the end, had carried its own weight. The law had answered. The dignity of the front row had been restored as much as it could be lawfully measured on the record. The next morning the building would open again. It would, as it always did, be waiting. In the months that followed, Magistrate Brennan would think often about the brass toggle. She would think about the maintenance worker who had bumped it that morning, who would never know that he had, by accident, fixed something in the building far older than the panel itself. She would think about Joyce at the stenograph, who had typed without pausing, who had not asked permission, who had simply done the work the building had hired her to do. She would think about Deputy Marquez at the door, who had taken 1 step forward at exactly the right moment and held the rest of his ground. She would think about Esperanza Vega, who had carried the case for 6 years on a contingency, who had heard the panel before Hollander did, who had said only 3 quiet words at the moment that mattered. She would think most of all about Judge Reyes, who had not raised her voice and who had not, in 9 years, ever needed to. The lesson, Brennan would write in the 2nd paragraph of her teaching note, was the same lesson the 1st paragraph had implied. The building, given the chance, did its job. The bench, given the room, did its job. The people in the front row, 6 families who had buried husbands and fathers and brothers years before the case had begun, were, by the patient hand of the law, finally seen by the record. The record, in the end, was the witness the room had needed. The chamber's intercom panel had, by accident, helped the record hear what it was supposed to hear. The building had taken it from there. It would, in its quiet and lawful way, take it the rest of the way.